If you don't already have an account, click here, create an account. If you have an account and a subscription, log in, follow along down here to where we see mortgages, and we are down here. The first presentment went to the CFO bank. Now we are at the second presentment dealing with the recording officer. Now, some people have stated upon research that where they are, they pretty much can record anything. But for the majority of people, that's not going to be the case. There's going to be a lot of scrutiny, and this is going to be one particular instrument where the recording officer is going to give you a lot of scrutiny. So I presume you have to make your own mind up of whether you want to walk in and try to record a satisfaction of mortgage or discharge of mortgage instrument over the counter. But if for whatever reason after research you think it won't be a problem and that's what you decide to do, if you do it, I suggest you get a certified copy of what was recorded right there and take that with you and prepare to convey your property to a trust or to another party or something. However, the majority of people, if you do that and you're rejected, I wouldn't make a fuss about it. I'd ask why peacefully. I wouldn't try to explain. I wouldn't try to, I wouldn't do any of that over the counter because you're kind of in the public and it's not the place for that. But I'm saying is if you can't record the satisfaction instrument on the record like that, then you're going to have to do a private administrative process to the recording officer and make them your fiduciary with respect to exercising your rights and with respect to the laws of the United States government under the reorganization and the national emergency, right? You see where it's all going, right? Because, once again, as I stated in an earlier video, these are constitutional officers. These elected officials, they take an oath to support and defend the Constitution. That's their offer. Your acceptance, as we're going to see, click right here. This is the contract. This is the contract to the recording officer. We have it right here in collateral. I accept your oath as required by New Jersey Constitution, Article 6, Section 1. How did I know that? Right? Because when I was going through the Memorandum of Law, as you should, you go through your state constitution and you read what the Bill of Rights in your state constitution is, and you see if any of that applies. Then you throw that in your Memorandum of Law also. But this is where it, talks about the oath of office. Remember, we looked at what constitutes an acceptance under a contract. So I accept your oath as required by New Jersey Constitution, Article 6, Section 1, which was given on January 1st, 2021, and the related surety bond number, B123456789, held by whatever the name of it is, insurance company, as collateral to guarantee that the fiduciary will not derogate from the Constitution or the laws of the United States of America as provided in the Memorandum of Law when performing the duties specified under this contract. Right? Now, of course, if there's any reason why the fiduciary can't perform in accordance with the laws and the public policy, then he can respond under penalty of perjury. He has some fiduciary duty to give full disclosure, to act in good faith, right? So they got to provide a remedy or they take on the liability. So this is the contract, but you see already in there, we're talking about the acceptance of oath. So I hereby appoint Anna, last name, as fiduciary to take care that the laws be faithfully executed under this contract, and hereby transfer the powers and legal estate provided herewith to dispose of in the manner set forth in Section 5B2 of the Trading with the Enemy Act of October 6, 1917, requiring the full discharge and full acquittance of the mortgage instrument number 1234 recorded on page 123 and book 123 of any town county recorder's office, and the transfer of assets in accordance with section 3113A and 3113E2 of Public Law 97-258 as a gift to the United States to reduce the public debt. Collateral, I accept your oath as required by New Jersey Constitution, Article 6, Section 1. I already went through that. And then we go in through the standard contract where we're instructing them, telling them what is required to be done. Acceptance and refusal. This contract shall be deemed accepted by the fiduciary if refusal to the appointment, authorities, and duties is not received by the principal at the address given above within 3 days of the postmark of this contract. It probably should be 10 days, 3 days, whatever. You can adjust your timelines as you see fit. Liability of the fiduciary. The fiduciary's excuse me. The fiduciary's failure to perform the duties set forth in this contract within the time allowed to perform said duties will comprise the fiduciary's agreement to the following. The fiduciary waives all rights, defenses, and immunities. The fiduciary accepts personal liability for damages up to 10 times the face value of the instruments. The fiduciary accepts filing of any documents and public records reporting the lien right of the principal in relation to the fiduciary's breach of this contract. The fiduciary accepts that the fiduciary's public hazard bond and or limited liability insurance policy shall be surety for any liens or levies executed by the principal for the fiduciary's breach of this contract. The fiduciary accepts that the fiduciary's real property, personal property, fixtures, and accounts shall be surety for any liens or levies executed by the principal for the fiduciary's breach of this contract. And did I read this? Or I know I read this, but I have to say it again. Acceptance and refusal. Any refusal of this contract must be accompanied by a sworn affidavit signed under penalty of perjury and stating that the fiduciary does not have the capacity, authority, obligation, and duty to 1. Set off, settle, and otherwise discharge the account. 2. Accept an appointment as fiduciary. 3. Negotiate, endorse, or ledger the instruments against the account for the benefit of the beneficiary. 4. Make these make sense according to the exact instruments that you present, because all of this and the default provisions of them not responding is the actual evidence of the transaction that you've executed. You may have 1099 forms, 1099As, 1099 OIDs, 1099Cs, because these 1099s go through the FIRE system, right? Which is, you can look that up, IRS FIRE system. It stands for something. But I also think it's code for what we see taking place in this redemption process. You're going through the FIRE to get this revenue or redemption or remedy for that matter. But what I'm stating is these are records of transactions held in government databases, which therefore seem to be eligible as evidence under the federal rules. So everything you have with your Notary Certificate of Non-Response, your Memorandum of Law, stating straightway the laws that you're relying upon, your acceptance of their oath to the Constitution, which makes them part of the national government that's under the national emergency. So all of this is evidence supporting the transaction, or the fact that the mortgage is discharged in full acquittance and that there is no liability to pay, has been discharged, right? That's the only thing we want to stand on. We don't want to argue about the legitimacy of the debt, in as much as the debt has been discharged with the date and the evidence of the transaction. And I think bringing that in the proper court and venue, because that may involve moving a claim to a United States District Court or something like that. But again, ultimately, let's go back to the lesson, or to the, not really the lesson, but this idea and this concept of discharging a debt that we're discussing. So that was like an overview of the presentment to the recording officer. But if you've seen what we pointed out there, we accepted their oath, we accepted the surety bond, and at this time you would have already seen the surety bond. You would know who the guarantor is, and this is where the rubber meets the road, or whatever they call it, right? Because now from here, either they perform, or if they don't perform, you can give them a notice of fault, an opportunity to cure, and there's templates down in here that I've put in here for that. And at the end of the day, if they don't perform, you can file a claim for breach of fiduciary duty. You can file a claim against the proceeds based off of your security agreement, your acceptance of their oath of office, and their breach of the contract, and you being damaged as a result of them not releasing the lien, them not performing under the acts of Congress with regard to the handling of these debts under the national emergency. So because the thing is, if we're not correct in these assumptions, then as a fiduciary, they have a duty to respond in good faith